Hi everyone, Harry here to talk about Donald Trump's 55-page motion in front of Justice Juan Merchan, the judge in the New York convictions, seeking to set them aside. Now, point one, I referred to this before, but in brief, but I've got a whole op-ed that somewhat presciently ran a couple days ago that we're going to link in here, but it's just this very point. So there's all this immunity issue, but remember what the New York convictions are based on, really paradigmatically private conduct. When he's a candidate and not in the presidency, he devises a scheme to keep any kind of word or information about trysts with women from coming forward, and then they execute that scheme. And all of this takes place before he's even president. The one thing that does take place after is the sort of paperwork, including signing of checks. But there's just because he's in the Oval Office doesn't make those official acts. In fact, on the contrary, when you're signing personal checks, and remember from the evidence at the trial, he actually sent it to a whole special place so it wouldn't be conjoined with the official payments and the like. So that's really front and center private, unofficial conduct. But, and here's the point in the op-ed, so the Supreme Court has really gone very far, and besides stating this immunity principle that everyone you've read about now in the press, they laid a few mines and traps that really matter here, it seems to me. And the number one thing that they said is that you may not use evidence of official conduct in order to prove unofficial acts. And it's that fulcrum that Trump uses in almost throughout. That's really his only point, but made as to 6 or 7 pieces of evidence to try to say he should get a new trial. And by the way, that's all he could be saying here, even if he, wins the lottery. The most he could be saying is evidence was improperly admitted, and therefore there should be a new trial. All right, so what kind of evidence are we talking about, and how does it dovetail with the Supreme Court's immunity opinion? Well, in the op-ed that we've linked to, the first, the one I mentioned, and the first thing it turns out Trump mentions is a conversation with Hope Hicks. Now, it's all about the scheme, but it's 2018. It's in the Oval Office, and it's about a Wall Street Journal article that's just been published where they have figured out the whole Michael Cohen payment scheme that happened in 2016. So talking about it with your communications director is at least arguably acting as a president. That's what you do with the communications director. Now, still, does that count as something that shouldn't have been admitted? One way that you have to analyze that is the Supreme Court, remember, lays out 3 different ways of categorizing action: unofficial, official, core official, and then sort of in the middle. So there will be a little bit of a fight here, but Trump, not surprisingly, says this is core official. This is the same kind of thing that the Supreme Court talked about with the Department of Justice. We don't have to know exactly what did he tell Hope Hicks or what it was about. You're in the Oval Office, you're talking to your communications director. That's just like, you're talking to a DOJ person. So that's core, and that means there's no way of justifying its admission. It's not like a rebuttable presumption. And one more thing as well that Trump tries to sell in his long motion to Merchan, which is that you cannot have harmless error. So let me double back now to what the analysis will be to the extent Merchan accepts it. So this Hope Hicks was, her evidence was admitted, and that's just the first of 6 or 7 things that he talks about. There's also Madeline Westerhout, who really just testified that Stormy Daniels had been there and hear how the Rolodex was kept, but that's kind of official. A few things about a response to government ethics. He files an official form that goes into that. Of course, I don't think that should matter because the Supreme Court said if it's a public record, then there's no worry about immunity as to it. But it's that kind of argument leading with HOPICs. So that's the basic claim with several of them. How will it be analyzed? Well, they're already anticipating, Trump, a harmless error analysis. In other words, let's say that HOPIC's testimony counts as sort of official stuff. Nevertheless, there's an argument that Trump waived it in the previous removal litigation. Unless it really becomes important, I won't talk about that separately. But there's also an argument that even if it shouldn't have been admitted, there's a lot of evidence out there, and it's what in a criminal review would be called harmless error. A little trouble there is that, well, first, Trump is saying it's core conduct and you don't even do harmless error analysis. But second, it was pretty strong evidence. It was played that way. And at the closing argument, the prosecutors talked about, quote unquote, it was devastating. So that's going to inform a harmless error analysis. But so the whole notion here is to try to get a new trial, not to throw out the convictions, but to say they had evidence that shouldn't have been in there. That evidence mattered, and therefore you get a new trial. All right, so that's the argument there. How's this going to work procedurally? The DA will answer this 55-page motion. I think the standard day should be the 24th, so the middle of not the coming week, but the week after. And it'll serve it all up to Mayor Chun. Mayor Chun can make a determination, and this is, remember, really caught up in the sentencing. Will this somehow derail the sentencing that has been set for September? And, that's got real political consequences because if Trump is sentenced to prison for a couple months, he won't be serving it. They would suspend it while he goes on appeal. But that's a pretty big, political punch. You've been convicted and you're supposed to go to Rikers Island for a few months. So that's going to happen. His motion here will be tied in with when does he sentence? And this is what we're going to see from Trump, a very aggressive move, and this is across the board with the different cases, to say whenever he's relying on immunity is a right not to be tried in the first place, not to have certain things introduced. So let's say Mayor Chun says, I've heard you out. I am not going to give you a new trial. I'm not throwing it out. Trump will try immediately to take an appeal, and even before there's sentencing pronounced. So to an appeal where? To the appellate level in New York. From there, the highest level in New York, which could take it or not. But from there, the U.S. Supreme Court, which lies at the ready, if depending on how zealous they are about backing up their very expansive and kind of nutty and deeply unfortunate immunity opinion, they could easily get involved and just reach down and say, boom, don't do the sentencing yet. First decide that and then bring it up on appeal. Okay, so that's the basic game here. Give us a new trial, even though this was all about unofficial action, because the additional principle that the Supreme Court stated of you can't even consider official conduct in deciding whether there's an unofficial action case to be made. That happened here. It wasn't harmless, and therefore there should be a new trial. So don't even think about sentencing yet. And then the final point, to the extent Mayor Chun disagrees, and for what it's worth, I think Mayor Chun will disagree, the effort by Trump will be to immediately take it up on appeal, even up to the United States Supreme Court, to totally freeze anything from happening before the election, to foil any effort of saying he has been not just a convict, but sentenced to prison, and just to use that immunity opinion. And it's like a huge arsenal of tools for him to keep that from happening. That's what we're going to see. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.